Good evening, folks. Welcome to Monday Night Law here, Kirk's Law Corner. March 16th, 2026. Hope everybody's doing all right out there. Been a kind of busy time for me. I've been house sitting and dog sitting. And I came home so I could do my Monday Night Law here for you folks. And something that's really been on my mind here again is the parental rights thing. So Tony Pellegrino and we were just discussing this stuff, and we're planning a We the People Idaho event, and we're strategizing on what to talk about and those kinds of things. And I think that's one of the hot topics. Now, for those of you who've been following for a while, I've been talking about how to file public corruption complaints. So this is going to tie right into that, right? This is just another thing that we have an issue with, and this needs to be redressed. So I want to say hi to everybody out here. Diesel D's, good to see you, brother. Michael Casper, Palindrome, Liberty and Justice, Dave O, Jim Valentine, Radar Star, that's a new one. Paint Gun Spooty, Windy, good to see you. Gail Hedrick, D.I., and another Gail. Let's see. All right. I know. Thanks, Diesel D's. Yeah, Tony and I, we've been friends now since 2016, and really need to get this going with, our plan, making this stuff happen. I hear on Rumble, good to see you, Karen, Amunzen58, Mark, good to see you, brother. All caps, false prophet, good to see you. So, let me see, I need to move stuff around here so I can see this better. Watching 3 different screens here. For those that don't know, for broadcasting, I have 3 screens. So, over here I've got the broadcasting software, the main one where I use Zoom to do the video part and capture this particular screen. And then everything else over here, Rumble, Telegram. So I got to watch comments over here. And the broadcasting software catches YouTube and X comments and Facebook comments. So if you're wondering why I keep looking around stuff, that's the reason why. So, anyways, yeah, Tony was just out in D.C. for court hearing, and actually in the District of Columbia, not as in Washington, D.C., Washington, but it's a family court case. So, was working with Christine there at the Parents United type thing there, and trying to get people to understand we don't need a law for medical kidnapping, which we will see. What we need is the people to get educated on what their rights are and how to effectively claim and exercise and defend those rights. At this point, when you're talking about like CPS coming in and taking your kids, you need to know what to immediately do. Now, here's my disclaimer. This is not legal advice. This is lawful education. Educating the people on what their rights are. That's the motto for, or the mission statement for Kirk's Law Corner. What are our rights? Where do they come from? And how to effectively claim, exercise, and defend them following due process of law. This is the hard part, following due process. Even though this is in my educational series, one specific dedicated to parental rights stuff. But sometimes it's great for a refresher, especially those that haven't watched it. So again, I highly recommend people watch my free educational series on my YouTube channel, Kirk's Law Corner. And you can get access through that to kirkslawcorner.com. All my social media links are on kirkslawcorner.com except for Telegram. Telegram's private, and since I moved it to private, I haven't been able to update that link on my website. But you'll see the list of stuff here below in the description for donations to help support me over here. If you enjoy learning from me, learned anything from this particular video or not, in general, buymeacoffee.com there is the going thing now for me, being, PayPal and Cash App took me down many years ago through the, taking the Patriots out type thing. So, greatly appreciate those that have supported in the past. Patreon. That's where predominantly I've been using until I was able to get something going with Buy Me Coffee. So, but Patreon, Tier 1 is $5 a month. Tier 2 is $10 a month. Tier 3 is Wednesday night workshop. That's private class Wednesday nights. That's where it's really at, folks. That's where I really dive into stuff, and where people can interact with me. I do open it up for questions, Q&A sometimes, mostly at the end, but I talk about other things that I don't talk about here on my lives because they'll get taken down. So we're in the private over there. We talk about some crazy stuff sometimes. So if you're interested in that, highly recommend getting over there on the Wednesday night workshop through Patreon. If you're looking for one-on-one time with me, special attention to answer your direct questions to help educate you. Again, not legal advice. This is education. So that's Tier 4. James out here on YouTube learned today that almost all law books are copywritten in Europe or Brittany, the bar. Imagine that. So, other than that, there's the toll and roll stuff that we're working on. Link to the website there, tollandroll.com. It's in the description as well. To help support Toll and Roll over there. There's a link to that. But people need to really read that stuff and download those documents and see what we're working on for the people. This is the restoration of the Republic. I'm working with Doge. Okay. Working with members of Congress to pass those bills, and working with Doge. So there's some serious stuff going on that we're working on through Toll and Roll. Okay, and I'm very thankful for those that have been working on that for years. And it seems that I came back into the picture just in the right timing. But You know, this is some of the stuff that Chris was working on at the time. This was his baby to start with, was the petition of remonstrance for what turned into toll and roll in 2019. Now, the first one was the one that we worked on in 2017, which is how E-Clause got created by the consent of Congress as loss prevention for the government of the United States of America. That's on the business license. That's how E-Clause got created, through what we were calling then as a petition of remonstrance. Lo and behold, there is a difference between a petition and a remonstrance, but there again, most people don't know. Because reading means reading. Of course. That was actually Billy from Toll and Roll. So, probably forgot that I do Monday Night Law, but here I am. So, the first thing I kind of want to do here is I want to play this video. This is the Hardwick versus Vreeken case. Okay. Okay, yeah. This was in the Ninth Circuit. This was argued in October 7th of 2016, Pasadena, California. Where is it? Oh, there it is. Okay, let's see if the audio is going to go through.
May I begin?
Yes.
Thank you, Your Honor. Good morning. May it please the court. My name is Pansy Lynn, and I'm here today on behalf of appellants and defendants in the underlying matter, Marcy Vreeken, Elaine Wilkins, and Helen Drozak by and through her estate. If I could reserve 2 minutes for rebuttal. Thank you. The facts underlying this case are many and sordid, and I won't go through them all here.
Thank you.
Thank you, Your Honor. And but I will summarize that there was a divorce. The divorce was followed by a raging custody battle, which ultimately led us into juvenile dependency court, wherein in those proceedings, the custody of 2 daughters was ordered removed by the juvenile dependency court from their mother. These 2 daughters were Kendall and Presley Hardwick. Presley Hardwick is the plaintiff in the underlying action and the appellee here. Fundamentally, this appeal presents 2 issues, whether the individual defendants were entitled to qualified immunity for their actions and whether they were entitled to absolute immunity for their actions or for the actions that they are being sued for.
Are you seriously pressing absolute immunity? It wasn't pressed at all in the state. Are you serious about that, or are you going to waste time with it?
I am serious. I certainly would not bring an argument to this court that I'm not serious about. I am serious about the argument because there are fundamentally acts for which our defendants are being sued, these social workers are being sued, that I believe come squarely within absolute immunity. I understand that qualified immunity is the issue here for substantively the removal pursuant to the court order of
Why don't you go to
children.
qualified immunity?
Of course, Your Honor.
We have your briefs on absolute.
Thank you, Your Honor. In terms of qualified immunity, as this court is aware, it's a two-prong analysis. The first being whether there is a constitutional rights violation that has been alleged, and the second prong being whether the constitutional right was clearly established such that our government actors know without doubt that what they are doing would be a violation of the law. The court is entitled to.
Okay, so for qualified immunity, which can be removed if it's a violation of a right. So here we go again. This is why it's so important to actually know what our rights are and we have to be able to speak them. That's what it means by claiming, is you speak it, right? Because God tells us that our tongues are sharper than a double-edged sword. That's what that means. When we speak the law, when we speak our rights, the law, that is what cuts them down. So, listen to what they're saying here, because I have the opinion as well. After this hearing, they gave their opinion. I have the opinion. Now, pay attention.
Take these prongs in any order it perceives, and here, typically when we have the qualified immunity analysis and whether the law is clearly established, it is typically plaintiff's burden to come forward to this court and say, here is the case law. This is what tells the state actors, the government actors, that they should have known better. It's clearly set forth in this case law. In our matter here, it's interesting because the reverse has actually happened. This court has actually found.
Yeah. See what she's saying there? It's been clearly said in case law. No. Our rights are the law. And the Constitution is the law of the land, which is the common law of the land. And that is what they are bound to support. Article 6, Clause 3. All this crap about their policy, the code, Roman civil law, and all their internal policy crap, that's what they say they go by. And it's like, well, okay, but this is part of what I've been trying to educate people on, is about doing the constitutional challenges, right, to all of this crap. So anyways, pay attention.
That as of the date of the underlying conduct here in 2000, when
You talk about Costanich?
that is correct. Your
Costanich
Honor.
deals with foster care licenses and guardians, not natural children of parents.
Costanich deals with the underlying liberty interest of a 14th Amendment claim, which is the same.
For foster
For
parents,
foster
though.
parents.
That is true. A guardianship.
And guardianship, not natural parents. It seems to me that as early as the 1940s, the United States Supreme Court has held that there is an absolute liberty interest, a fundamental liberty interest that parents have in the care, custody, and control of their children. That's been on the books forever. I have a whole bunch of Supreme Court cases I can read from. That's just going to waste a lot of time. They have that fundamental constitutional right. And it cannot be impaired without due process of law.
And where the qualified immunity.
Now, what did he just say there? Plenty of Supreme Court cases that say it's a fundamental right, fundamental liberty interest into the care, custody, and control. Care. How we care for our sons and daughters. And this is the key. The words that we use. Right? I want to stress this. Stop using parent and child. Start using mother, father, son, daughter, and property. That's your property. You have been deprived of your property. And what did he just say? Can't be deprived without due process of law. That's due process of law is synonymous with law of the land. So that has to come from the 4th, 5th, and 6th Amendments. Because that's the process that is due. Many people don't understand that, but that the 4th, 5th, and 6th is the process. We have the right to be secure, and no warrant shall issue but upon probable cause, supported by oath or affirmation. There's a process there. And notice that it says, no warrant shall issue but upon probable cause. All this, well, we had probable cause to go get a warrant. Did you go get a warrant? Because that's the process of the Fourth Amendment. To get a warrant, you have to have probable cause. You can't make an arrest just because you think you have probable cause. You have to have judicial oversight. The judicial branch is the ones that issues the warrants. That's the process that is due.
Analysis in the clearly established law plays into this is, do we have case law that tells us that?
No. You've read Help versus Pelzer. There doesn't have to be case law. There can be other ways of showing that it's clearly established. Case law is not an absolute requirement.
It is.
Have you read Hope versus Pelzer?
Case law is not an absolute requirement. But see, they want to subvert the laws of nature, naturally, fundamentally, and principally. The common law, right? But this whole semantics here drives me nuts, because this judge up here, he gets it. This woman over here, she doesn't. She's playing the bar code stuff, the bar way, trying to figure out how to screw people over and justify and try to go for absolute immunity. She wants to argue absolute immunity because she knows that they're in deep doo-doo.
Pelzer and all the other cases that talk about that?
Yes, Your Honor.
Okay, there does not have to be a case on all fours.
You're correct.
Correct.
There does not have
Okay.
to be a case on all fours.
Right. What isn't clearly established here?
The fact that what Costanza says, what's not been clearly established in the year 2000 when this removal occurred was the idea that the right to be free from deliberately fabricated evidence in civil child abuse proceedings that result in the deprivation of a protected liberty interest, the same liberty interest.
A civil. How is that civil? There's the first problem, folks. It has to be criminal in nature. But this is part of that Roman civil law. The Roman law.
But it's not the same liberty interest, because this was a parental liberty interest.
It's a biological versus foster parent.
That's huge. That's gigantic in terms of what somebody could appreciate and understand. How in the world could a person in the position of, we have to take the facts as they're pleaded in the light most favorable, so, we're not trying the case. But how could a person in the shoes of your clients possibly believe that it was appropriate to use perjury and false evidence in order to impair somebody's liberty interest in the continued care, custody, and control of that person's children? How could they possibly not be on notice that you can't do that?
I understand the...
How could that possibly be?
I understand the argument that it seems to be common sense and our ethical...
It's more than common
morals.
sense. It's statutes that prohibit perjury and submission of false evidence in court cases.
State statutes.
Are you telling me that a person in your client's shoes couldn't understand you can't commit perjury in a court proceeding in order to take somebody's children away?
Of course not, Your Honor.
Of course not.
Then isn't the case over then?
And the case is over.
Yep.
Because...
Costanich is distinguishable in my view. How in the world? Costanich deals with a secondary care, foster care. That's a whole strange thing. It's not a person's real child.
Even if Costanich is...
And guardian's the same thing.
Even if Costanich is distinguishable, there is... Thus far, we have not been presented with any clearly established right that tells us that what our clients did, which is remove the children pursuant to a court order.
No, but what they're accused of doing and what the issue is here is committing perjury in a court to take away someone's children. And you just said that's obviously not okay to do.
According to our moral compass and our ethical guidelines, but what we're here to decide is the constitutionality of it, and we look to the courts.
You mean due process is somehow consistent with a government official introducing perjured testimony and false? How is that consistent? I mean, I hate to get pumped up about this, but I'm just staggered by the claim
I mean, look at these
that
guys.
people in the shoes
All
of
of
your
them.
clients wouldn't be on notice that you can't use perjury and false evidence to take away somebody's children. That, to me, is mind-boggling.
In criminal proceedings, we know this to be true because that.
No,
law
no,
was
like criminal
clearly
proceedings, it's a court proceeding with a liberty interest, a fundamental liberty interest at stake.
And on the reverse side, the state.
And you're
also-
telling us that these officials who do this all the time couldn't be on notice that you can't commit perjury and put in false evidence?
I understand broadly the principle that common sense tells us that lying is wrong and lying to.
Yeah, but it's more than
forces-
common sense. We're not using common sense. We're using the statutes, for example, against this kind of behavior.
I was not presented, I have not been seen any federal law, case law, or law that tells me that in this situation that we were faced in, which is what we have to
Well,
look at.
say your clients hired 6 people to be actors and to go into court and say, we're neighbors and we saw all this terrible stuff. And then your clients presented those witnesses in court. You're telling me that they would have no reason to believe that you can't do that because there was no federal case that says you can't bring actors into court to swear falsely against somebody.
But again, here we're appealing to sort of a broader definition of what is a clearly established right. I mean, we have to find the clearly established right in the context that our.
The clearly established right is thou shalt not bear false witness from the 10 Commandments. At the root of all law. That's the common sense law. That's the fundamental principle and rule of law, that thou shalt not bear false witness. Somebody was saying to mention the judge's name from left to right. I believe down here in the bottom left, it's Trott, Owens, and Friedland. I believe that was Karen that was asking. Yeah, Karen, out on Rumble. So there you have it.
Social workers were presented with, which was they were faced with a court order.
You know, again, I can't even believe for a microsecond that a caseworker wouldn't understand you can't lie and put in false evidence.
Let me ask the question a different way, counsel. Was there anything you know of that told social workers that they should lie and they should create false evidence in a court proceeding?
No, and of course, that is, we contend that that's not what happened here.
I understand. Look,
Yeah, we're stuck with the facts, and the light most favorable.
And to be clear, we are only speaking that
Right.
we accept the pleadings as alleged. We are not saying any of this is true. I want to be very clear about that. But
Right.
that's what we're dealing with right now. Is there anything, I mean, look, you've got your clients, you're doing your best to represent them here. But from our perspective, you see where we're coming from here. So help us. Okay, we've talked about Costanich, and we've said that case there's some language in there which I understand what you're pointing to. I got you. But as Judge Friedland, Judge Trotta both said, it also does have a different interest. So is there any case besides Costanich that you can point to and say, here's Ninth Circuit, this is the answer?
Well, what I would contend, Your Honor, is that was plaintiff's burden to do when it came to qualifying.
No, I understand that's your argument, but just for your sake, because you reached to Costanich, which if I were in your shoes, I'd be reaching for it too, as hard as I possibly can. Is there another case? You got one hand kind of on the ledge here with Costanich. Is there another hand you can grab another Ninth Circuit case where you've got a firm grasp? You can say, see, I've got it.
In terms of another Ninth Circuit case that instructs social workers to lie and cheat.
Or at least sets a time period. At least sets a time period that says, as of this date, you can't do this anymore.
Other than Costanich, Your Honor, I do not have any such case in front of me.
As a matter of fact, Snell precedes all of this, and we have cited Snell with approval on many occasions.
Understood, Your Honor. Snell did precede this.
And we've embraced Snell in our published opinions.
In the context of criminal proceedings, yes, that is true.
Snell wasn't a criminal proceeding.
I believe Snell involved a criminal proceeding, an affidavit for a warrant, I believe was the underlying issue.
We can look that up if there's any question about that. But you mentioned nothing other than Costanza. Now, they're going to come up and they're going to talk about the Green case, Green versus Camreta. What's your response? And look, and I will acknowledge our case law is not entirely clear on this. Okay, so I don't fault you for having to dance around these two cases. But Green, what's your response to Green?
Green does not clearly establish the law as it was in the year 2000. Green was decided in 2009, involving conduct in 2003.
But all those cases talked about conduct that it was previous to the conduct in this case. They referred to cases that referred to conduct that was earlier than what happened in this case.
Correct, but again, in the context of criminal proceedings.
But Green cites them as establishing a principle beyond criminal, right?
Right.
It does. And, you know, one thing that we read in Costanich, and I understand we're sort of beyond that, but, you know, there is a difference between civil child abuse proceedings and criminal proceedings.
But doesn't Green stand for the proposition that that's not true?
Even if it did, again, it is post-conduct authority that our clients would not have been aware of. And Your Honors raise a good point when you say the case law is unclear. I mean, our own district court judge made that comment that, you know, as between Green and Costanich, it was very difficult to reconcile. And I would submit that if it's difficult for courts and it's difficult for judges, it certainly would be difficult for us.
Can we back up for a second and talk about whether we even get to this issue? Because why do you think that qualified immunity wasn't litigated in the state court? Why aren't we bound by what the state court said about qualified immunity?
Well, the state court's analysis in terms of qualified immunity, I don't think was, did not comport with the federal court analysis.
I mean, that may be, but isn't that not a factor in estoppel analysis? I mean, aren't we bound even if the state court got it wrong, as long as it had jurisdiction, it decided the issue? If it cited the wrong cases or said the wrong thing, we're still bound by it as long as it was decided, aren't we?
I would submit that the issues were not identical that was submitted to the state court versus the issue here. Yes, the term qualified immunity was used, but the underlying, in our view, the case law had changed.
Wasn't the issue whether lying in court to deprive a familial relationship was clearly established? They didn't say clearly established, but wasn't there a question, wasn't the question in state court whether there was qualified immunity for lying in court to deprive a familial relationship?
The question, correct, there was an issue of qualified immunity. Now, they did not do the two-pronged analysis. And
right, but that gets to citing the wrong cases. So what's the difference in the issue that was decided?
Our argument here is that Costanich changed the lay of the land. And when there is a change in the law, California courts have held that collateral estoppel cannot bind.
But that's when the change in the law is like, is this the statute that this is about, or is that the statute that this is about? The state court was talking about qualified immunity. Now, maybe they made a mistake, or maybe you think they cited the wrong cases, but there was no issue of like, now California law under this statute is totally different. It was still qualified immunity.
That is correct, but there was a change in the law in terms of the federal qualified immunity doctrine and how it applied to the facts of this case.
I mean, is your only basis for that Costanich, which we've earlier said we don't really think changed anything relevant?
It's Costanich, and it's also the fact that Green, which came out after the fact, you know, it made these connections in terms of civil and criminal child abuse proceedings.
How is that relevant to what you think the state court did? I mean, your first response is the state court didn't really look at this the way the federal courts do anyway. So if we start there, then does it matter what Green and Costanich said?
It matters because the issue has changed. And if the issues are not identical, we don't have collateral estoppel.
But isn't the issue still qualified immunity for lying in court to deprive a familial relationship?
It is. The issue in the state court was the familial relationship of the mother. Here we are dealing with the familial relationship of the children, so that is a different aspect of the issue. There are different rights involved there. And the issue is the difference in the law that, the landscape of the law that changed after the fact.
All right, thank you, counsel. We will go ahead and you got a lot of questions, so we'll give you 2 minutes in rebuttal, okay?
Thank you, Your Honor.
Good morning, Your Honors. May it please the Court, Dennis Ingalls on behalf of Presley Hardwick, the plaintiff and appellee. As this Court hit upon, Costanich is readily distinguishable. There are a few additional points which I'd like to point out. Mrs. Costanich wasn't even a guardian in the probate court sense of the term. She was a dependency guardian. She was just tasked with taking care of these children while the natural biological parents' dependency case ran its course. Contrary to what counsel
So
says,
you wonder what kind of a liberty interest there would be in that relationship.
virtually nothing. And if you look
Exactly.
further into the proceedings that took place in Costanich, there was a administrative law judge who was then appealed to a CPS judge, if you can imagine such a thing.
CPS, Child Protective Services?
Right. In that case, in that state, they call it DSHS. I forgot what it meant. But they appealed it to their own Board of Appeals. And that person said, well, what does it matter if they lied, because we couldn't do anything about it anyway. So the nature of the rights at stake are just worlds apart, as this Court hit upon. Contrary to what counsel said, Green didn't establish anything. I think the Court realized this. Green said there are these older cases that established this a long time ago. Lying is bad. Obviously bad. It's unconstitutionally bad. Pay your money, do not pass go. This case took place 16 years ago. They lied. A jury awarded nearly $5 million. They kept fighting the proposition that lying is bad. It turned into nearly $10 million, and they're still here fighting the proposition that lying is bad. I would simply ask their appeal be denied, and I would ask the Court that you issue a published opinion so that some stubborn count in the future doesn't come back and say, well, Costanich, this, that, and the other.
How does
do we know?
collateral estoppel work here? It seems to be that the state failed to address one of the primary questions specified by the Supreme Court that's dispositive, and that's whether the law is clearly established. I can't find anything in the state proceedings anywhere that suggests that anybody confronted that issue and decided it. And if that's true, what does that do to collateral estoppel?
Collateral estoppel still applies, Your Honor. They did not specifically use the words clearly established, and although the words clearly established were part of the case law dating back to Harlow, prior to Saucer versus Katz in 2001, there wasn't this necessary two-step where you had to have a subject heading in every opinion that you wrote as a judge. And there's the merger concept, which I outlined in my briefs, which Butler versus L., Liston, Franks have all talked about, where the clearly established component of qualified immunity doctrine is consumed by, swallowed by, merged with the deliberate falsehood question.
Is collateral estoppel something that let's say you're right about what the state court decided. Does that mean we have absolutely no latitude at all as to whether to accept that? In other words, we take a look at it and say, boy, that's what the answer was, but they blew it. They didn't know what they were doing. Are we still stuck with it?
I do think
in the
this
federal
case
courts?
we are bound by collateral estoppel, but even if you went past that and hypothetically said no, this case it's astounding to me this case is still being fought.
You
because
don't
it's
need
so
collateral
simple.
estoppel
You
to
don't need
prevail.
it. The lies are on paper in a transcript, the deliberate falsehood, and the but-for causation set forth in Franks.
Are
and
you
its
still
progeny.
pursuing Vrieken?
Yes, absolutely.
And what was her status coming out of the state case?
Vrieken, there was a sizable damage award ordered against Vrieken.
Against Vrieken?
I believe you
Who
might
was the
be-
one who was exonerated?
Wilkins.
Okay, Wilkins, excuse me, I misspoke.
Yes, our claims against Wilkins are still alive. Now, the jury will do what it will, as it did in Deanna Hardwick's case, but those claims are still alive right now in this case.
Are you alleging violations of the Fourth Amendment and the 14th Amendment?
We are, Your Honor. My client, as a minor, was actually seized, so there's your Fourth Amendment right there.
Do we need to distinguish between them? Is there any difference in whether we think about this as Fourth Amendment or 14th Amendment?
No, there's no difference in the standards whatsoever.
I'm falling in love.
Of course, gotta throw a commercial in there.
Unless you have anything else, I think we're good with questions for you.
One other little point is that California Government Code 820.21 has been on the books since 1995. It's 820.2 tells government actors in the state of California you get immunities for using for discretionary acts. 820.21 came out, it said, unless you lie, cheat, and steal. So don't do that. With that, I would rest.
There's your clearly established
Thank you, counsel.
that you can't lie,
All right, you've got your rebuttal
steal,
time.
cheat.
With regard to Mr. Ingles' last comment on 820.21, that is a state law. It does not bind the federal court in terms of what is constitutional and what is not.
Doesn't that weigh on the question of whether something is clearly established that an official could understand what the official could and couldn't do?
It could.
I mean, in Hope versus Pelzer, to go back to that case again, they use all kinds of things in that case to say that it's clearly established, not just cases that have been decided by anybody.
Yes, Your Honor, that is true. A court is entitled to utilize several factors.
So why isn't that what he said significant?
Individuals are not bound by our own individual sensibilities in terms of what is right and wrong. We are bound by what the courts tell us are clearly established law, whereas the courts can rely on other factors to tell us what clearly established law is.
Are you telling us that your clients don't have to pay any attention to the California government code?
Absolutely not. They absolutely do. But here we are in federal court on a federal civil rights action, deciding what is constitutional and what is not.
And what case prior to Hope v. Pelzer said that you can't tie someone to hitching post?
I am drawing a blank, Your Honor. I'm sorry.
I think the point of Hope was that there wasn't a case exactly on point, right? So
Exactly.
we don't have an exact case here saying that people can't lie to take kids away from their parents, but Hope says we don't need one.
We don't need an exact case, but we don't define our constitutional rights broadly. We need clearly established law that tells us how to act in the context that we are
So
acting.
why isn't the government code significant and relevant?
It's in my view, it is not. State law does not dictate what is constitutional and what is not.
It doesn't dictate, but it adds considerable evidence to the question of whether your clients would have been on notice. You can't do this.
It could. It could.
Right, because
I mean,
statutes
it's not
are
just what
government
somebody told them in a
policy.
conference, it's state law under the government code.
That is true,
Government
but
code.
that's not what happened here. And that's, we haven't been presented with any law telling us applying this particular state code to the circumstances that we have here. I see
Okay.
my buttons blinking.
Thank you very much, counsel. This
Thank you,
matter
Your
is
Honor.
submitted. Thank you both for your argument today, and we are in recess. Have a good weekend.
Now, we've actually got to hear the whole hearing on this. A lot of people just cut to that one part, but hearing both sides and the commentary from the judges, clearly they're like, well, wait a minute. Yeah. So, all right. Now, let's take a look at our Idaho Code statutes, Idaho statutes. Now, this is our Parental Rights Act. So, here it is in the code, or in the statute, I should say, in the code, but this just says Idaho statutes. Okay, this is the Idaho statutes from the Idaho legislature. So, this is allegedly the act, right? We need to make a law for that because, we got to have this government code. Oh, hi, Kathy. Good to see you. Yeah, coming in late. I see you. All right. So, Idaho has this. I don't know if every single state has this. But here's the thing. Where does this so-called parental rights come from? This is the real question. These are not constitutional rights. None of these are constitutional rights. Okay? So, here's the preamble for Idaho. We, the people of the state of Idaho. Now, notice that how state is not capitalized, but Idaho is. Is there a distinction here? There is. Grateful to Almighty God for our freedom to secure its blessings and promote our common welfare, do establish this Constitution. So, we're establishing this Constitution to what? To secure our rights and to promote our common welfare. Wait. That means the General Welfare Clause, that's to promote our common welfare. In securing our rights to be free. Now, Article 1, this is our Declaration of Rights, which should not be part of the Constitution. It should just be a Declaration of Rights. Because this has nothing to do with the instrument of government. So, but we use the inalienable rights of man, which they're actually unalienable, unable to place a lien upon them, because our rights are actually our property, and you cannot put a lien on those rights as that property and hold them until we pay some debt. That's what our founders meant in the Declaration of Independence when they wrote unalienable. They didn't use the word inalienable. But notice that it's rights of man, not person. It's rights of man. Because we are creations of God. Period. We're not fictions. We're among the living. All right, so again, proper diction, right? These words that we choose to use from law, diction, law, jurisdiction, the words we use puts us under what bodies of law? Now it says, all men are by nature free and equal, and it should be free and independent, like it says in the Law of Nations and many of the other states' Declaration of Rights. Because the independent part is independent of all things created by his fellow man. That's what it says in the Law of Nations. And have certain inalienable rights. But these are certain unalienable rights from the laws of nature, which Blackstone talks about in his commentaries, is that these are the primary absolute rights. So when we're talking about parental rights, from the laws of nature, it is an absolute right. We don't need anything in the Constitution because this is a fundamental law. And it comes first. Everything is built around it. Everything is built for it. Right? That's part of the preamble there, that we're grateful to Almighty God for the blessings of liberty, or the blessings of freedom. All of these rights are from nature. This is the laws of nature. So, and have certain inalienable rights, among which are enjoying and defending life and liberty. Enjoying and defending. So that's like claiming and exercising, enjoying. We're supposed to be, Fourth Amendment, we're supposed to be free. Right? The right of the people to be secure in their persons, papers, houses, and effects from unreasonable searches and seizures. So, acquiring, possessing, and protecting property. So we have the right to acquire. What is possessing? Possessing means using, the free use. And we have the right to defend it. Just like we have the right to defend life and liberty. And pursuing happiness and what? Securing safety? Wait a minute. I thought the government does that for us. Under the General Welfare Clause, we're making sure that you're safe out there. See? You know what this really does right here? You know, they like to use the 10th Amendment and say, well, it doesn't say that we can't. Yes, it does, right here. This is a Declaration of Rights. This is an automatic prohibition. These are the rights of man. Why is it the very first thing? Pretty important, isn't it? So, if these are powers retained by the people, see the 10th Amendment, then that is an automatic prohibition to the states. Automatic. And see, I just figured this argument out the other day, based on my own case here, because they like to quote that 10th Amendment there. Well, it doesn't say that we can't. And, but yes, it does. Because, again, let me show you. Section 2. All of it, all political powers inherent in the people. This means the people are the sovereign, not the legislature, not the executive, and not the judicial. Because, remember, the Constitution doesn't exist yet. It's created by the people. It's the instrument of government. Who has to create that? Only the sovereign have the power to create. So, government is not the sovereign. And this is statistically stated right there. All political power is inherent in the people. Well, we've got broad policing powers. That's policy-making powers. No, you do not have broad policy-making powers. You only have the powers that are delegated by the people through the Constitution. They'll admit that in the federal Constitution. Well, yeah, the federal Constitution, if the powers are delegated there, then we can't exercise those powers. But the Constitution doesn't say that we can't do something. Again, it's the same principle because all of the political power is inherent in the people. Therefore, you only have certain powers that are delegated. That's how the Constitution works. American Jurisprudence, Volume 16, Constitutional Law, Section 1, the very beginning of constitutional law. The constitutions are the supreme written will of the people, and it is absolute and paramount. Right? Let's just pull that up, right? I'm gonna pull that up because it's a good time to show that. I'm pretty sure. I'm pretty sure this is a good time. What are we saying here? All right, so American Jurisprudence. This is 2017 update, August of 2017. So it's not that old. It's 9 years old now. But trust me, this hasn't changed. Not going to change. So I'm not using old, outdated American jurisprudence here. Definition and nature of Constitution and constitutional law. This is the definition. As used herein, the word Constitution means a declaration of fundamental laws or principles for the government of a nation or state. It's for them. Oh, wait a minute. Wait a minute. Huh. A constitution represents the supreme written will of the people regarding the framework for their government. Where a constitution asserts a certain right or lays down a certain principle of law or procedure. Okay, pay attention here. It speaks for the entire people as their supreme law. And it is the paramount authority for all. For all. That is done in pursuance of its provisions. A constitution thus embodies fundamental values and articulates the citizens' common aspirations for constitutional governance and the rule of law. I wonder what footnote number 4 is. Martin versus Beer for City of Dickinson, Tennessee Circuit Court of Appeals in 1995. That might be a case to go read because that happens to be a pretty prominent case here. So this would be your estoppel. See, that's the rule of law. Now, sometimes we talk about the common law, blah, 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 but the thing is, this is the common law. This Declaration of Rights is the common law. Rights as the law that are common to all. Many people do not comprehend that. But let's go to American Jurisprudence, Volume 16, Constitutional Law, Section 100, that explains that. Generally, a constitution, usually a declaration of principles of the fundamental law. Wow. 100 sections later, or 99 sections later, it's still saying the same damn thing. So we need to start using these words that this is the fundamental law. This is the rule of law. Many of its provisions being only commands to the legislature to enact laws to carry out the purposes of the framers of the Constitution, or mere restrictions upon the power of the legislature to pass laws. Wait a minute. So when we're talking about the Declaration of Rights, this is laying down the fundamental principles of due process of law, what our rights are. The fundamental principles, the fundamental law, the rule of law. Where does it say, and the legislature shall have authority to make legislation regarding this right? It doesn't. So because it doesn't delegate that power doesn't exist. But just in case I'm wrong, we'll clarify that from American jurisprudence. Back to Hardwick versus Vreeken case there. Well, we don't necessarily need case law for that. But here you go. Because remember, American jurisprudence is just a compilation of the case law. American jurisprudence is the science behind the law. So, what does it say? However, it is entirely within the power of those who establish and adopt the Constitution to make any of its provisions self-executing. That is, operative without any necessity for further legislation. That would be all of these rights in a Declaration of Rights. Right? This is a Declaration of Rights. Nowhere in here. Okay, why does it keep skipping? Oh, okay. All of these rights. Oh, well. Let's see. I think this one here, the rights to hunt, fish, and trap. But I don't see the right to keep and bear arms. Oh, there it is. The people have the right to keep and bear arms, which right shall not be abridged. Miranda versus Arizona, there shall be no rulemaking or legislation that would abrogate a right. But this provision shall not prevent the passage of laws to govern the carrying of weapons concealed on the person, nor prevent passage of legislation providing minimum sentences for crimes committed while in possession of a firearm, nor prevent the passage of legislation providing penalties for the possession of firearms by a convicted felon, nor prevent the passage of any legislation punishing the use of a firearm. No law shall impose licensure, registration, or special taxation on the ownership or possession of firearms or ammunition. Nor shall any law permit the confiscation of firearms except those actually used in the commission of a felony. So the last two sentences there actually quash the previous part. No law shall impose licensure, registration, or special taxation on the ownership or possession of firearms or ammunition. That negates, it nullifies anything to do with passage of laws to govern the carrying of weapons concealed on the person nor concealed carry. Why can't it just be simple? The right of the people to keep and bear arms shall not be infringed. There's no legislative authority granted. But this is the trickery. But then this is where Article 6, Clause 2 comes in, that the judges in every state, the Supremacy Clause, that anything in the Constitution, again, anything in the Constitution or laws of a state to the contrary is notwithstanding, which means it is void for any effect. So, how is this possible? This is actually void. Everything that I've just highlighted here is all void for any effect because it's in conflict with the Second Amendment, the supreme law of the land. It's void. It should end right there, shall not be abridged. There should be, shall not be infringed, meaning no legislative authority. But see, this is where they granted legislative authority. But then, again, no law shall impose licensure. Oh, you have to have a license to carry concealed. No law shall impose licensure, registration, or special taxation on the ownership or possession of firearms or ammunition. Again, that just totally wipes out. But this provision shall not prevent the passage of laws to govern the carrying of weapons concealed on the person, nor prevent passage of legislation providing minimum sentence for crimes committed while in possession of a firearm. Right there. No law shall impose licensure. So we're done. But anyways, that one actually does, right? Say, and the legislature shall have certain powers. The rest of these don't. The joys of having a dog. Hey, go lay down, please. Go lay down. So these are rights, right? This is the common law. Plain and simple. This is the common law, right here. Declaration of Rights. Okay. All right. So now, let's go look at what legislation they made regarding parental rights. This section through 32.10.14, so 1010 through 1014 shall be known and may be cited as the Idaho Parental Rights Act. Remember what they said in Hardwick versus Vreeken? The interest and role of parents in the care, custody, and control of their children are both implicit in the concept of ordered liberty and deeply rooted in our nation's history and tradition. Now, for those of us in Idaho, and in fact, everybody can cite this. If you don't have something similar to this in your state, you most certainly can cite this right here. Because what are we talking about? Fundamental law. This is deeply rooted in our nation's history and tradition. Pay attention to the next sentence. They are also among the unalienable rights retained by the people under the 9th Amendment to the Constitution of the United States. Not the 14th. 9th. Because this comes from the laws of nature. Life, liberty, clearly, like they said, well, it's a fundamental liberty interest in the care, custody, and control of their children. So, you have to know these words. You have to know what your rights are in order to speak it. Right? Oh, I know what my rights are. Okay, well, tell me. Well, no, then you don't actually know what your rights are. You have the gut feeling, but you can't speak it. Knowing means being able to speak it. So there's the first kicker. Okay? And this is Idaho statutes, Title 32, Domestic Relations, Chapter 10, subsection 1010. I need to put this on. Get on there and lay down. Now, the interest of the parents include the high duty and right to nurture and direct their children's destiny, including their upbringing, medical, and education. So this right here puts that outside of the scope of government, right? Because this is deeply rooted in our nation's history and tradition. This is a right protected, retained by the people. Oh, I do, Karen. I'm very loving. He is a good dog, but he's a little whiner right now. Something going on out front that he thinks he needs to be a part of. And anyways, I say good boy, by the way. So, high duty and right. So, okay, who the hell are they? CPS or whatever they call it in your state. Who are they to tell you what you can and can't do with your children? They have no authority. None. As we will see. The state of Idaho has independent authority to protect its parents' fundamental right to nurture and direct their children's destiny, upbringing, and education. No, the state of Idaho does not have independent authority. Go back to this one. Inalienable rights of man. We enjoy and defending life and liberty. We protect our property, pursuing happiness and securing our safety. So no, the state of Idaho does not have independent authority. You have no authority. None. Zero. Because this is the limitation right here. So, trickery. It all starts off good, and then they give themselves power. Well, we have the independent authority to protect its parents' fundamental right. Taking jurisdiction where they have none. The protections and rights recognized in sections 32, 10, 11 through 10, 14 are rooted in the due process of law guaranteed pursuant to Section 13, Article 1 of the Constitution of the State of Idaho. Would that be the Fifth Amendment? Now, here's the thing. When we say due process of law, many people think, well, that's only for criminals. It's not. In all criminal prosecutions, the party accused shall have the right to a speedy and public trial, to have the process of the court to compel the attendance of witness in his behalf, and to appear and defend in person with counsel. No person shall be twice put in jeopardy for the same offenses, nor be compelled in any criminal case to be a witness against himself. I just claimed that. Nor be deprived of life, liberty, or property without due process of law. So, this makes no distinction between the criminal side or the civil side. If you're going to deprive life, liberty, or property, we have the right to a trial by a jury. We have the right to a certain process. That process comes from here, not from a statute. Law of the land. Okay? Governmental efforts that restrict or interfere with these fundamental rights are only permitted if that restriction or interference satisfies the what? The strict scrutiny standard provided in section 32.10.13. Uh-oh. Okay. This is called a test. This is a test. This is the governmental compelling interest. They're only permitted if it satisfies this strict scrutiny standard. It's a test. To pass this test, okay? Nothing in this act shall be construed as altering the established presumption in favor of the constitutionality of statutes and regulations. What is that? Presumption. There's the key. It's automatic presumption that everything is constitutional of these statutes and regulations until it is objected to. Then they have to go find the rule of law. They have to go back to the history and tradition of the right, which is what I've showed recently in State versus Clark. That's what they did. So, but that's it. And this is their get out of jail free card, right? Well, nothing in this act shall be construed as altering the established presumption in favor of the constitutionality of statutes and regulations. That's it. Well, we can make whatever we want, and it will be presumed that it's constitutional unless you object to it. Right? And I found it. In my case here, uh-oh, what is this? Under the rules of evidence, presumptions in civil cases generally, presumptions in criminal cases, In a criminal case, unless otherwise provided by statute, in criminal cases, presumptions that operate against the defendant recognized at common law. Wait a minute. Or created by statute, recognized at common law. That's right. The common law is the real law, folks. Are governed by this rule. For purposes of this rule, statutory provisions that certain facts are prima facie evidence or other facts or of guilt are treated as presumptions. This is what I just did. Submission to jury. The court must submit the question of guilt or of the existence of a presumed fact to the jury only if, on the evidence as a whole, a reasonable juror could find guilt or the presumed fact beyond a reasonable doubt. Instructing the jury when the existence of a presumed fact operates against the defendant, the court must not instruct the jury to find a presumed fact against the defendant and must not instruct the jury in terms of a presumption, which is exactly what I objected to. The presumption that failure to identify equates to resisting and obstructing. Uh-oh. Uh-oh. That's right. And I did my own jury instructions, and they were denied, and I objected to those denials. Yeah, I don't know, Jacqueline. I need to write a common law book. I probably should, you know. Just make it real super simple. Get rid of all this complicated. All right. So, the provisions of the Idaho Parental Rights Act are hereby declared to be severable. And if any provision of the Act or the application of such provision to any person or circumstance is declared invalid for any reason, such declaration shall not affect the validity of the remaining portions of the Act. Okay. What that is saying, declaration, you mean declaratory judgment? To declare it unlawful and unconstitutional? What that is self-preservation. It's like, oh, well, if for some reason a certain part of this act, say section Section 4, the state of Idaho has independent authority to protect its parents' fundamental right to nurture, direct their children's destiny, upbringing. No. That's unlawful and unconstitutional. That delegates the state as its independent authority. No. Sorry. Unlawful and unconstitutional. This is made by the legislature, which subverts Article 1, Section 1, Declaration of Rights. But let's go through the rest of these because, like it says, parents who have legal custody of any minor child or children have the fundamental right to make decisions concerning their care, custody, and control. So, when we're talking about this medical kidnap, it's not them. They have no authority to determine what care we provide for our children, medical care or otherwise. The fundamental right to make decisions concerning their care. Not the hospital, not the doctor, not anybody else. which goes back to Blackstone's commentaries on the laws of England, under the right of personal security, that right to life, right? We have the fundamental right, the absolute right to make decisions regarding our own health care. That's a fundamental, absolute right from the laws of nature. Okay? But there it is. But we need to make a law for that. Medical kidnapping. It's right here. Here's the law. It's already here. They don't have that power. This is a fundamental right retained by the people. It's right there. There's the law. Remember what they were talking about in Hardwick versus Freakin case there. Crap. Okay. The next one. Parents who have a legal custody of any minor child or children have the fundamental right and duty to make decisions concerning their education, including the right to cause the child to be educated in any manner authorized under Section 33202 Idaho Code and Section 9, Article 9 of the Constitution of the State of Idaho. No. How about we just stop right there? Right here. That's it. The rest of this is void for any effect. It's a fundamental right. We get to choose how we educate them, not government. Article 1, Section 1 prohibits that. This legislation, this portion right here, is void for any effect. Now, here's what stops that other one, right? Except for, This is where they're in with the Juvenile Protection Act, right? Their Child Protective Act, right? Interference with fundamental parental rights restricted. Neither the state of Idaho nor any political subdivision there may violate a parent's fundamental and established rights protected by this act, and any restriction of the interference with such rights shall not be upheld unless it demonstrates by clear and convincing evidence that the restriction or interferes with both essential to further a compelling governmental interest and the least restrictive means available for the furthering of that compelling governmental interest. The foregoing principles apply to any interference, whether now existing or hereinafter enacted. Nothing in this act shall be construed as invalidating the provisions of the Child Protective Act in Chapter 16, Title 16 of the Idaho Code, or modify the burden of proof at any stage or proceedings under the Child Protective Act. But I thought it had to be in compliance with due process of law. And these are the presumptions, right? When a parent's fundamental rights protected by this act are violated, a parent may assert that violation as a claim or defense in a judicial proceeding and may obtain appropriate relief against the governmental entity. If a parent prevails in a civil action against the state or a political subdivision thereof, as provided in subsection 4 of this section, the parent is entitled to reasonable attorney fees and costs. All be damned. You don't have to be a member of the bar to get your attorney fees and costs. Okay. Now, I want to go back to where they talk about the governmental compelling interest here. Now, here's parental rights and medical decision making. Well, we already covered that. It's already up there. But see, 32.10.15 is not 10.10 through 10.14. Now, This was just added in 2024. Parents have the fundamental right and duty to make decisions concerning the furnishing of health care services to the minor child. Except as otherwise provided by court order, an individual shall not furnish a health care service or solicit to furnish a health care service to a minor without obtaining the prior consent of the minor child's parent. Well, duh. It's a fundamental right to the care, custody, and control of their children. Subsection 3 of this section shall not apply, and a healthcare provider may authorize or furnish a healthcare service without obtaining the informed consent of the minor child's parent if a parent of the minor child has given blanket consent authorizing the healthcare provider to furnish the healthcare service, or the healthcare provider reasonably determines that a medical emergency exists. No. Okay, wait. Furnishing the healthcare service is necessary in order to prevent death or imminent, irreparable physical injury to the minor child. Or, after reasonable diligent effort, the healthcare provider cannot locate or contact a parent of the minor child, and the minor child's life or health would be seriously endangered by further delay in the furnishing of healthcare services. No healthcare provider or government entity shall deny a minor child's parent access to health information that is in such healthcare providers or governmentalist control and requested by the minor child's parent. This section, right, shall be construed in favor of a broad protection of parents' fundamental right to make decisions concerning the furnishing of health care services to minor children. It's not furnishing health care services. It's the decision making, whether they get the care or not. Period. This section does not make legal and in no way condones euthanasia, mercy killing, or assisted suicide, or permit an affirmative or deliberate act or omission to end life, including any act or omission described in section 1840-17, other than to allow the natural process of dying. But, it's kind of already here. But I want to go back to that governmental compelling interest here. $10.13. Huh. Where's the test? Where's the strict scrutiny standard test? It doesn't tell you what it is. But I'll tell you what it is. It's willful. So criminal in nature. Willful neglect. Depriving the child of food. Willful neglect. Criminal in nature. Depriving the child of clothing. That's it. The only other thing is willfully, physical abuse and sexual abuse. Those are the 4 elements. That's it. That's the test. Do you have evidence that the parent willfully deprived their child of food? Willfully. Criminal in nature. Not, hey, we're poor and I can't afford to feed him. That's not willful. That's not criminal in nature. Number 2, willfully deprive them of clothing. Well, here's the thing. Sometimes we see babies running around with just diapers on. Sometimes they're running around with nothing on. So who gets to determine, right? Who gets to determine how it's willful neglect? I mean, I guess if you were to send them to school in some serious raggedy clothes or without clothes, then that would be a little bit of an issue, right? You would think, right? But then the question is it done willfully or is it because they're poor? And so this is where we get in there and say, okay, is it criminal in nature or is this you need some assistance, you need some help? Because under Title 4D, anytime that they're to get any funding for any of this, it was flat out. It flat out says in Title 4D funding that it must be done, what? With the intent to keep the family unit together. Now, here's the thing. Let's say there is physical abuse or sexual abuse going on in the home. We remove the criminal, not the children. Because we don't want to upset the children's home, right? We don't want to upset their friends, their family, all of that stuff. Okay? That's to keep the family unit together. We remove the criminal, not the children. But see, they want to traffic the children. They want not only the money, but they want to sell them off, right? This is where that Nancy Schaefer was talking about why she got murdered, was there's over 850,000 children a year that come up missing from state custody. I'm not talking about ones that are kidnapped out the street. We're talking about the ones that are kidnapped by CPS. They go into state custody and disappear. And this was back in 2014. 16 when she said that, 2016. Okay, 850,000 children a year that come up missing from state custody. So, that's the strict scrutiny standard for a governmental compelling interest. And yes, you most certainly have the right to sue them. All right. We'll come back over here because we didn't cover the rest of that on Section 100. Now, this is Constitutional Law, Section 100, Volume 16, Constitutional Law, American Jurisprudence. Criteria which may be relevant in determining whether a constitutional provision is self-executing or not include a description of the right in detail, such as the means for its enjoyment and protection. The absence of any directive to the legislature for further action. Like I showed you. Yeah, under the right to keep and bear arms, it says, oh, they can make legislation. This is exactly what that's talking about. A particularly informative legislative history as to the provision's intended operation. Oh, would that be the history of the right? And a consistency of self-execution with the scheme of rights established in the Constitution as a whole. Oh, damn. Meaning they're off limits. Observation, Captain Obvious here. Even without the benefit of a declaration that they are self-executing, constitutional provisions in bills of rights and those merely declaratory of the common law are usually considered self-executing, as are provisions which specifically prohibit particular conduct. A clear distinction exists between the questions whether a constitutional provision is mandatory or directory and whether it is self-executing or requires legislation in order to give it effect. A provision may be mandatory without being self-executing, and a provision may be self-executing even though it contains some mandatory language. But the key is the absence of any directive to the legislature for further action. And what is it? Even without the benefit of a declaration? You mean like a declaration of rights instead of a Bill of Rights? Better get over there. Go lay down. Go lay down. All right, come here. Come here. So, that's the key part of all of this right there, right? The absence of any directive to the legislature for further action. Then that's off limits. You don't have legislative authority. Okay, Karen out here in Rumble. What could get confusing? States are to help other states. Union. Yes, it's okay. Okay. Now, this is the opinion from that hearing that we looked at earlier, watched earlier. The panel affirmed the district court's denial on summary judgment of absolute and qualified immunity to social workers who plaintiff alleged maliciously used perjured testimony and fabricated evidence to secure plaintiff's removal from her mother, and that this abuse of state power violated her 4th and 14th Amendment constitutional rights to her familial relationship with her mother. Now, see, this was the daughter. Right? This was the daughter that sued. Ah, okay, Karen, you're talking about the self-executing. Okay, what it's talking about there being self-executing means it says what it says as it is written. It stands as it is written. It's executed in the manner that it says as it is written. It doesn't need further legislation. That's what self-executing means. And it is mandatory, right? When we're talking about Declaration of Rights, that's mandatory. Shall not be infringed. The word shall is mandatory language. Now, that's that other part there that's in section 98 and 99 that talks about shall or may being mandatory language. So, anytime there's the word shall, that is mandatory language. So, shall not be infringed. Yep, there I go again, breaking it down so grandma can understand it. Common layman terms, common sense terms. The common man terms, I should say. Okay. The panel held that the social workers were not entitled to absolute immunity from claims that they maliciously used perjured testimony and fabricated evidence to secure plaintiff's removal. The panel held that the plaintiff's complaint targeted conduct well outside of the social worker's legitimate role as quasi-prosecutorial advocates in presenting the case. The panel held the defendant's case for qualified immunity was not supported by the law or the record. The panel determined that plaintiff produced more than sufficient admissible evidence to create a genuine dispute as to whether her removal from her mother's custody violated her constitutional rights. The panel further stated that it could not conceive of circumstances in which social workers would not know and understand that they could not use criminal behavior in any court setting to interfere with a person's fundamental constitutional liberty interest. Yes, absolutely right, Diesel D's over here on Telegram. That's right. Constitutions are above statutes and the code. And the federal constitution supersedes all state constitutions pursuant to the Supremacy Clause. Yep. And this is the key part. That's why they want to say, well, the Bill of Rights doesn't apply to the states except for by and through the 14th Amendment. Hogwash. That's why we have to comprehend that the Bill of Rights is actually, the real verbiage there, is that these are articles in addition to an amendment. These are not amendments. The Bill of Rights is the amendment to the Constitution. And therefore, these are articles. Article the first, Article the second, Article the third. Now, that's contract law. And it becomes part of the Constitution as additional articles. So, this is what happened with the Reconstruction Acts. They changed that to confuse the people. Yeah. So, whoops. Now, I want to get down here to my favorite part of all this. I think it's on page 9. I thought it was on page 9. Over the years, the Supreme Court has recognized this fundamental right in many cases. For example, like what they were saying, there was lots of cases, this fundamental right, right? What they do claim is that the specific granular right to be free from deliberately fabricated evidence in civil child dependency proceedings, where a parent's or child's protected familiar liberty interest is at stake, had not yet been clearly established prior to the dependency proceeding issue. They concede that the rights oppression relies upon had been clearly established in criminal proceedings against parents, but not yet in a civil proceeding context. We disagree. All right, so here's the kicker for all of this, right? No official with an IQ greater than room temperature in Alaska could claim that he or she did not know that the conduct at the center of this case violated both state and federal law. The social workers in this case are alleged to have knowingly and maliciously violated the law in their attempt to sever Presley's protected relationship with her mother. Perjury is a crime under both federal and California state law, as is the knowing submission of false evidence to a court, 18 U.S.C. 1621, California Penal Code subsection 118. Both crimes make no distinction between criminal and civil proceedings. This malicious... Whoa, what the hell did I just do? What the hell? Boy, did I just... Well, that was a new one. This malicious criminal behavior is hardly conduct for which qualified immunity is either justified or appropriate. The doctrine exists to protect mistaken but reasonable decisions, not purposeful criminal conduct. As the Supreme Court repeated in Sheehan, officials who knowingly violate the law are not entitled to immunity. So, do you have an IQ greater than room temperature in Alaska? If you don't, you're incompetent. All right, folks. That's it for tonight. I hope that helps somebody out there. I most certainly hope that clears some things up about what our rights are and what to claim there. Okay? So, again, much love. Have a wonderful night. God bless. And we'll see you Wednesday night for Wednesday night workshop. All right? Other than that, we'll see you next